Today I want to talk about federal law regarding employee efforts to form a labor union. It's very important for supervisors and managers to understand the limits imposed by the law so that no employee rights are violated. By the time we're done today, you should understand what laws apply, how to identify unionization efforts, and what the law permits you as an employer to do in response to a unionization campaign. First, let's talk about the law that applies here. The National Labor Relations Act, or the NLRA, applies to your company whether or not you are currently unionized. The Act protects employees and their right, essentially, to complain to one another about working terms and conditions. The reasoning is that unless employees are allowed to discuss their salary, their benefits, or other terms of employment, they cannot decide whether organizing a union might be beneficial for them. For example, if you are in the lowest paid department in the company, you won't know that unless you can compare your salary to others. The Act protects these type of discussions. The National Labor Relations Board, or the NLRB, is the government agency charged with enforcing the Act. Employees who believe they have been treated unfavorably in violation of the Act can file a charge, which is basically a complaint, with the board. As a recent example of a charge filed by an employee, you may have read about some of the complaints filed by employees who were fired for Facebook postings they made that were critical of their employer. Some of those terminations in employment were reversed. This is just a recognition that today, discussions about working conditions can take place on social media as well as in person. You may be wondering, why would it ever be okay for employees to say bad things about you, their employer, on social media? Well, we're back to the National Labor Relations Act. Section 7 of the NLRA covers the rights of employees and provides in part that employees shall have the right to self-organization, to form, to join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all of such activities.